It's a real pleasure to be here today. I've heard a lot about these events, and this is the first one that I've been able to attend as the executive director for the Chautauqua Region Community Foundation. I just want to take a minute. I know that they're not in this room because they're running around keeping the place comfortable for all of us, but can we thank the staff at the Jackson Center and the volunteers for what they do for us? And then it's always dangerous. I lost sight of Greg for a minute, but we should really thank Greg because without his creativity and his connections and tireless work, these things would not happen. So thank you, Greg. So this morning we're going to kick off with Alan Bozer, who is a partner with Phillips Lytle. His practice focuses on both criminal and civil cases, as well as appellate and arbitration work. He received his undergraduate degree from Harvard, which is something to be proud of. But what he is most proud of, I understand, is the fact that he participated in intramural boxing, and he was co-champion of the middleweight division during his time at Harvard. So to kick off Alan Bozer's presentation, I think we have a short video.
How much you weigh, Slim? And you weighed 168 pounds. You were beautiful. You could have been another Billy Kahn. That skunk we got you for the manager, he brought you along too fast.
It wasn't him, Charlie. It was you. You remember that night in the garden? You came down my dressing room and said, "Kid, this ain't your night. We're going for the price on Wilson." You remember that? This ain't your night. My night, I could have taken Wilson apart. So what happens? He gets the title shot outdoors in a ballpark, and what do I get? A one-way ticket to Palookaville. You was my brother, Charlie. You should have looked out for me a little bit. You should have taken care of me just a little bit so I wouldn't have to take them dives for the short-end money.
Well, I had some bets down for you. You saw some money.
You don't understand. I could have had class. I could have been a contender. I could have been somebody. Instead of a bum, which is what I am. Let's face it. It was you, Charlie.
Alan Bozer is the bum, Greg? Well, unfortunately, that took away a little bit of my presentation, but we'll come back around to it. The important point of that portrayal that you just saw was Marlon Brando, of course, is the principal, the beneficiary of a fiduciary relationship with his manager, his brother, and his brother had sold him out. And so when we talk about fiduciary duties and the obligation of a fiduciary, this is a very good way to start. The Ali Act, which will be part of our presentation, addresses exactly this sort of thing, and so we'll get to that. We need the curtains pulled. Anyways, while we're doing that, my name is Alan Bozer. I am a partner with Phillips Lytle. I have wonderful partners that I work with. I cherish the opportunities to come down to Chautauqua, where my family has had a place for over 60 years. So I get down here whenever I can. I've litigated against some great advocates down here. I saw Chuck here earlier, Tad Wright, the Wright brothers, and Joe Molinari in the Wright office. I'm always delighted to get down here and happy to make Chautauqua County part of my practice. I also work closely with Chuck Hall from time to time. Thanks, Chuck. So let's start off. I think everybody knows the phrase by Cardozo that when talking about a fiduciary relationship, it's not honesty alone, but the punctilio of an honor the most sensitive is then the standard of behavior. When making out causes of action for complaints, both in commercial matters as well as you can understand in estate matters, the breach of a fiduciary duty is something that we plead regularly. I can't say that we always think about it as much as we can. We go look for the case law that supports our cause of action. There it is, breach of fiduciary duty. But what is a breach of fiduciary duty? First of all, it arises out of a fiduciary relationship. A fiduciary accounting summarizes all of the activity within a trust or an estate. What we saw in the opening movie bit, however, takes us a little bit further. A fiduciary relationship doesn't always give rise to a money accounting. It can simply give rise to the need for the fiduciary to account to his principal and explain why he did something. So that when you saw Marlon Brando turning to his brother and saying what he did, what he's saying is, why did you sell me out? You was my brother, Charlie, he said. You should have looked out for me a little bit. You should have taken care of me, and that's what a fiduciary is supposed to do. There's a presumption, of course, that if you deliver property into the hands of a fiduciary, he's going to do that and take care of that task exactly, and that is to be able to report back as to what he did. What is an accounting? Well, the court can order an accounting at any time if the beneficiary or the fiduciary comes in front of them and says, now's the time to account. When ordered by the court is free to define the scope of the accounting. So, for example, we had a case in front of Judge Cass over the past few years. It's reported in the law reports. It had to do with a fiduciary who took the corpus of a trust from his mother who had passed away. And so the question was, when doing his accounting, would the son, who was the successor trustee, have to do an accounting of what the mother had done, the predecessor trustee? And in that case, with guidance from the court, we did a full review of what the mother had done in trying to come to a conclusion. The fiduciary relationship. Accountability is the primary principle of the fiduciary relationship, as we saw with Marlon Brando. Missing sums of money or other assets, undervalued assets, exorbitant fees paid for simple services, fees paid for unauthorized or illegal services can all be surcharged against the fiduciary, and that is, if the fiduciary hasn't done her job, she's going to have to account for it, and if there's anything missing, she's going to have to make up for it. Now, where does the concept of a fiduciary come from in Western law? And it all goes back to Hammurabi. My son-in-law, who married my daughter, is constantly asking me about Hammurabi's code, as if it would be something that I didn't really know about. So over the years, I've had the habit of going back to Hammurabi's code to find out exactly what you're talking about. And Hammurabi lived around 1600 BC. And it's written that while the definition of a fiduciary was handed down by the Romans, the concept of the fiduciary commenced with Hammurabi's code. So we've got two laws that I put up here, law number 264 and law 112, written back in the 1600s BC, which talk about fiduciary duty of a herdsman. Of course, in those days you had herds of sheep and herds of cattle, which were the primary entrustment going on in an agrarian society. And so what these laws said, if I deliver my flock, say of 100 sheep to you and pay you a fee, over the course of a year, I expect to get back 100 sheep plus however many sheep were born to the flock, so I can expect 120 sheep back in a year. Hammurabi, in codifying the law in this situation, said yes, the herdsman who takes that flock has a fiduciary duty to tend over those sheep, to watch over them. The shepherd idea is something that permeates our Judeo-Christian background, and that is the good shepherd is somebody we look up to. And Hammurabi did the same and said when the shepherd comes back, he better have 120 sheep the following year, or he's going to have to make up for it. And as it says in 264, he shall make good the increase or profit which was lost in the terms of settlement. That is when he settles his accounts. So we see the fiduciary duty going back all the way to 1600. Those laws came down to us. First they came over to the Israel area and then permeated throughout the Western Basin. And then we come to the wrath of Achilles, the Iliad. All right, so what does the Iliad have to do with boxing? Well, when you have a chance to look at my syllabus, which I obviously am not reading here today, nothing more annoying to me to sit in a seminar and have somebody simply read the syllabus that he's given you. You can do that on your own time. But in going back and just researching what happened to the concept of the fiduciary, in the Wrath of Achilles, also known as the Iliad, we find the funeral games at the death of Patroclus. So now those of you who are still up on your Greek will remember that when Agamemnon offended Achilles by taking the priestess from the temple Briseis, Achilles went into his tent and refused to come out. So his lover, his best friend Patroclus, put on Achilles' armor, went out to battle against the Trojans, and was slain by Hector. This infuriated Achilles, and that's why we call it the Wrath of Achilles, who then went out, fought Hector in one of the great epic battles described in Western literature, slew him, and then dragged his body around the walls of Troy so Hector's father could see it, took the body back to the camp, and then began the funeral games. As part of the funeral games, we find at Book 23 a description of a boxing event. And in that description of the boxing event, there's a prize fight. The winner would receive a 6-year-old mule, described as one of the more difficult animals to try and train. The winner got a 6-year-old mule, and the loser got a 2-handled cup, and that's in the story. The important thing, I think, in bringing out, if I'm here to introduce the story about Muhammad Ali, is the boast that was made at the time by the boxer Epius, who held up his hand, and in something reminiscent of Ali and talking about the greatest, had this to say: "Whoever wants the cup, step forward." Now, the cup was second prize. So whoever wants the cup, step forward. No man will beat me with his fists and take the mule, since I'm the best boxer. I say, I may not be the greatest warrior. A man can't be best at everything, but this thing is for sure. Whoever I fight, I'll tear his flesh to ribbons and break his bones. I hope his kin are here to take him away when I've felled him. It's a little reminiscent of listening to prize fight introductions, especially back in the Ali time, but Ali backed it up. In those days, there were no boxing gloves, but what they did was they wrapped their hands in oxhide thongs. So they wrapped them in leather in order to protect the hands. Heavy blows were landed, as described in this story from the Iliad. There was circling of one boxer by the other, and ultimately Epius knocked his opponent off of his feet, knocked him down like a fish that leaps in the weed-strewn shallows under a ripple stirred by the north wind, then falls back into the dark wave. So his opponent leapt when he was struck. Now, I think all of us will agree there's no fiduciary duty of one boxer to the other. That is a manly combat, at least in those days. It's changed over the years. And the idea is to knock your opponent down, to beat him so that he doesn't come out. In that case, it talks about Epius, who went over to his opponent, lifted him and set him on his feet, and all his friends crowded around and supported him from the ring, his feet trailing, his head lolling as he spat out clots of blood. He was still confused when they sat him down in his corner and had to fetch the cup, his prize, themselves. Classic description of a knockout in one of the best reportings of boxing matches from the ancient days. What happened to boxing over the years? Well, boxing moved from ceremony to sport with its inclusion in the Olympics. It started in the Olympics way back in 700 or 800 BC and lasted up until about 390 AD when the Emperor Theodosius banned the Olympics as an unchristian-like parade of violence, etc. In those days, as you'll see in the fourth bullet point, gladiators during the Roman times would wrap their hands and forearms with leather straps, sometimes studded with metal shards called the cestus, and battle it out, often until death. Now, not every boxing match ended that way, but many did, which resulted in much of the Roman world banning boxing as too brutal in 30 BC. It lasted that way for over 1,500 years, and boxing doesn't make a comeback until the 1500s. In the meantime, the fiduciary concept continued to evolve. On the right is a mosaic of Justinian that shows up in a church in Italy, in Ravenna. But the Justinians Code focuses in on the fiduciary duties of principle of the fiduciary. And Justinians Code is very interesting if you go back and read it, how it's phrased. It's always phrased as the emperor writing to somebody out in the provinces. In this case, Justinian was codifying law in the 6th century, law that had actually been passed in the 4th century, about 200 years prior. And so the Emperor Diocletian, one of the great persecutors of the Christian church, had this to say to Gerontius: anyone who has administered the affairs of another, either as a guardian or in any other fiduciary capacity, must render an account of the same where he transacted the business. And you can see that was given in 292. Justinian's Code was adopted by much of Western Europe, and as a result, the idea of the accounting passed from Roman law into Western European law, finally into the English common law, and ended up here in America. So the fiduciary must account. Under our laws of the state of New York, estates and other accountings go to the surrogates under the Surrogate Court Procedure Act, Article 22. Supreme Court, though, has concurrent jurisdiction for trust accountings under CPLR Article 77. Now, the standard of review is this: a fiduciary has the burden of proving her account is complete and accurate. I've had a number of trials, and in order to carry this minimal burden, it's often a simple matter of putting the fiduciary on the stand, because the fiduciary has the burden of proof, and asking the fiduciary, is this account complete and accurate? A leading question, yes, but everybody wants to get to the main part of it. The answer is yes, it is complete and accurate. I tender the witness. Now, it could happen that the objectant's attorney sitting there could say, wait a second, you didn't carry your burden, but it hasn't happened in my experience, because the objectant is sitting there waiting to go forward with his objections. Now, to those of you without a lot of experience in this area, I can say this in giving some background. The accountant puts together an account which lists all of the property that came into her hands, all of the income that came as well, all of the expenses that the fiduciary incurred, and then presents that to the court and says, bless this court and give me a decree that I can go forward, that I've settled my accounts. And that acts as a release to the fiduciary, who can get on with life, and the beneficiary knows that he's had an accounting that is complete and accurate as to everything the fiduciary did. In the event, however, that the beneficiary says, wait a second, what about that $500 you used to buy a car for yourself that you never used? Well, then the beneficiary goes to an attorney generally and has objections prepared and entered. And the objection says, this particular asset was not properly delivered. This income should have been more. Go back to Hammurabi. We should have gotten 120 sheep and we only got 100. These expenses were improper because they involved conflict of interest and self-dealing. And so those objections are then listed. In our course of things, there is a period of discovery, depositions are taken, documents are exchanged, and then comes the trial, at which point the fiduciary's attorney puts the fiduciary on the stand. Is your account complete and accurate? I tender the witness, and the objectant's attorney stands up and starts cross-examination. Now, the objectant has the burden to establish that the predecessor trustee failed to discharge her duties as trustee. That was written recently in a case I had before Judge Cass, INRI White, lasted many years, but that's generally the way things go in most accountings. The objectant has to stand up and then disprove the fact that this is complete and accurate, to show self-dealing, to attack the fiduciary for not having carried in good faith and the punctilio of an honor the most refined, as Judge Cardozo said. And that's where the the ring is for the fight between the objectant and the fiduciary, out of which comes a decree which releases the fiduciary and gives the beneficiary some understanding of exactly what happened. Now, the fiduciary's direction, as stated by INRI White, by Judge Cass, it is within the discretion of the successor trustee to determine whether to exercise his or her power to contest, compromise, or otherwise settle claims in favor of the trust. What does that refer to? The case I mentioned earlier, which was INRI White, was the successor trustee had to figure out what his mother had done with a lot of the assets that had gone out of the trust over the years, and no documentation really existed to justify why those monies had gone out. The trustee looking at it had a real problem in INRI White for this reason. He had received the corpus at his mother's passing. It was well over $1 million. And he said to his sister, you know, things went well enough that Mom really took care of herself. There's nothing extravagant. And the fiduciary said, here's my accounting as to some of the bank accounts. Take a look. If you agree, let's just get this done between ourselves. I'll give you half of all the money. He said, and this became a question of fact at trial, he said, well, she agreed that everything looked copacetic, and so then I gave her $550,000, took $550,000 myself, and thought everything was done and over with. Doesn't work that way. So a year or two later, having reflected upon the amount she got, and having reflected that the money that went to her mother may have ended up with her stepfather, who she really didn't like, she decided to file challenges. That put the fiduciary, my trustee, to quite a burden, because now he had no money in his bank account to pay his attorneys, and at the same time, he had to try and figure out what his mother had done with the few $100,000 that had gone out of the trust that hadn't been documented. It's at this point that the courts said that the trustee has discretion. And so the fiduciary in that case had to decide, I've got no money in my bank account, I've got a stepfather out in New Mexico, and here we are in Chautauqua County. How am I going to pursue that? And oh, by the way, it looks like the estate of my mother, the decedent's estate, has no money in it either. And so if I want to get that money, not only do I have to follow the trail that, without any documentation, go against the decedent's estate that has no money on it, but then go beyond that to the stepfather with fraudulent conveyances that he had received money improperly. And so the trustee decided to exercise his discretion, said, this would be too costly, I'm not going to do it, and then he had to justify himself to the surrogate as a result. That took a 2 or 3 day trial in front of Judge Cass, and ultimately we came out with decisions. Those are a matter of record, and the accounting one of these days will finally be completed. And that case has only taken, about 6 years, I think, Your Honor? But we're going to get there. All right, where a fiduciary has failed to keep or produce clear and accurate accounts and records, all presumptions are against him and all obscurities and doubts are to be taken adversely to him. This is a matter of law, and it is a very powerful tool. A fiduciary who can arise in a power of attorney situation, fiduciary can arise in an estate situation, can arise in a trust situation, must maintain records. And it's at this point I want to refer to a trial I had about 25 years ago up in Niagara County with a judge called Judge Hannigan, also known as Hanging Judge Hannigan, because if you had a criminal matter in front of Judge Hannigan, you got the maximum. But he was also sitting as the estate attorney, so he took no nonsense when it came to these things. In that case, I represented the beneficiary against a fiduciary who didn't have records of what had happened. We went through deposition, and I would ask him, well, there's a $6,000 diversion from the trust back in 1981. What happened to those funds? And the answer was, well, I think I invested them in a car wash. I said, what happened to the car wash? Well, it went broke. What was the name of the company owning the car wash? I don't remember. I don't have those records. It was $6,000. Yes, it was. And so we went to trial. Judge Hannigan, up in the old courtroom of Niagara County in Lockport, sat up on his bench. The witness was tendered to me after the obligatory, is this true and accurate and complete? Yes, it is. I tender the witness. And I said, well, Mr. McDonald, I said, what about this $6,000? Now, discovery is supposed to make trial easier because we know what the answers will be. And sure enough, he testified exactly as I said. At one point, though, after we had gone to the second or third such situation, Judge Hannigan looked down and said, I've been listening to the fiduciary now for about an hour, and I've heard a lot of I don't knows, and I don't have any records, and I don't recollect. And Judge Hannigan, who stood about 6'3" and had a very long arm, then turned from his podium and pointed to the left with his arm and finger out and said, we're going to get answers to these questions, or Mr. McDonald, you're going to go across the street and spend the night there thinking about this until you remember all of the answers. At which point he recessed. I sat down with opposing counsel and we settled the case. But that's the important thing. A fiduciary must have records. And in an absence of records, as it says here, all obscurities and doubts are to be taken adversely to him. Not having a record of the $6,000 investment in the car wash proved fatal to him, and that was one of the items that he had to pay $6,000 as a result, simply because he had no records. A full and complete disclosure is central to the accounting procedure. A fiduciary has a duty of total candor with regard to any release of liability. This has come up recently in a case just decided by the Fourth Department a couple months ago, INRI Estate of Alford. We represented in that case the beneficiary, and the fiduciary had done this. The fiduciary was a well-respected attorney in Buffalo. He had prepared an interim accounting and presented it to our client. It showed a variety of stocks on it and valued it at $1 million. In fact, at the time he presented the interim accounting to our client, the stock was actually only worth $600,000. The explanation that we got afterwards was that he had used the valuations as of the time of the filing of the petition and not at the time that he gave his interim accounting. At trial, Dennis McCoy was the attorney on the other side from Barclay Damon, did a terrific job of discrediting our client, the beneficiary. Isn't it true, he would say, that you had looked up the value of these stocks over those months? Isn't it true that your wife kept careful spreadsheets of these stocks and what was happening with them? Isn't it true? And on and on and on as we sat there and cringed, and it came out that it appeared that our client, the beneficiary, actually knew what the value of the stocks was when he received this interim accounting that showed them worth $1 million when, in fact, we could prove they were only worth $600,000. So the point of the cross-examination at length, torturous. Remember that cross-examination is the next best thing to torture, is what many people have said. After this tortured examination, they rested, and the surrogate ruled that in this case, the beneficiary actually knew what the value of the stocks were at the time the interim accounting was presented, the $1 million, rather than the $600,000 we could show was actually the value. We went to the Fourth Department on this. Now, the Fourth Department looked at it and said, a release should be subject to careful scrutiny, and the executor must affirmatively demonstrate full disclosure of material facts which he or she knew or should have known. Now, the important part of that he knew or should have known has to do with the fiduciary, not with the beneficiary. And our main theme of argument was that the burden of proving full disclosure never shifts from the fiduciary. It's not enough to show that the beneficiary knew or should have known that the stock was only worth $600,000. What needed to be shown was by the fiduciary, and did the fiduciary show that the value was only $600,000? I can tell you this, for those who practice in the Fourth Department, it was, again, a torturous experience because all of the questions seemed to be going against us. which goes back to a shibboleth that I have, and that is you can never tell at the Fourth Department how you're doing, because many cases come out where the Fourth Department sounds, the appellate division sounds like they're going your way, and then comes a decision, and in this case, the Fourth Department agreed. It wasn't for the fiduciary to show what the beneficiary knew or should have known. It's for the fiduciary to prove full disclosure. So when the fiduciary presented the interim accounting showing the stock worth $1 million, that was it. He would have to defend that. And he was unable to do so, relied on this other, had a terrific trial strategy, which unfortunately didn't work. So we're back now with a full accounting going before the interim accounting all the way up to the end. Last night, John Sullivan's name came up. Don, I remember. John Sullivan was the last bare-knuckle boxing champion in America. It's interesting to read stories about John Sullivan. For example, the last couple of fights, they would get on a train in New Orleans, but Louisiana's governor had called out the National Guard and said if they try to fight, it's prohibited, and just lock them all up. So everybody got on the train. They didn't know where they were going. The train ultimately ended up in Mississippi. They went into an oak grove, and these two gentlemen, boxers, John Sullivan and another, ended up having their fight. The fight was a match that did not follow the rules that we know today. Of course, there were no gloves on, but importantly, it went 79 rounds. How did it go 79 rounds? Well, whenever somebody was knocked down or slipped and fell, they would take a break for a few minutes and then go back at it. So I guess one or the other of the boxers fell down 78 times or was knocked down. But John L. Sullivan ended up being the last bare-knuckle boxing champion in America. I believe he also became the very first recognized heavyweight champion in America. Right, Don? Yeah. Boxing gloves actually were invented in early 18th century England, but prize fights were still bare-knuckle. And John Sullivan was the last of them. Let me turn quickly to a parent's fiduciary duty, because this comes back into play as well. Parents have fiduciary duties to their children. We don't think about it that way. We think of them as natural duties. But when considering a fiduciary duty, it's the facts and the relationships that make out the scope of the fiduciary duty. And it is properly described that parents have fiduciary duties to their children to furnish adequate food, clothing, shelter, medical attention, and education, as well as to protect them from the outside world. I'll come back to that, but I'll observe this. In the case of Holodoc v. Spencer, a child sued his parent for something bad that had happened to them. This was not an automobile insurance case, which has different rules that apply. But what the court said was this. First, it observed that a parent's failure to observe fiduciary duties and standards of care can result in remedial sanctions, such as the forfeiture of custody or even criminal convictions. But the court in Holodoc said it does not include a civil action by the child against the parent for failure to protect. If the instant negligent supervision claims were allowed, the court said it would be the rare parent indeed who could not conceivably be called to account in the courts for his conduct toward his child, either by the child directly or by virtue of other procedures. So the parent's fiduciary duty is important, includes protecting the child. Which brings us to the Marquis of Queensbury in the late 19th century. John Douglas, the 9th Marquis of Queensbury, is best remembered as the avenging father of Lord Alfred Douglas and the man who encompassed the ruin of his son's lover, Oscar Wilde. At the bottom there is Oscar Wilde on the left and Lord Alfred Douglas to the right, and the father, the 9th Marquis of Queensbury, is a buff. I think he's described as a beefeater sort. He's also described in the books as one of the more loathsome human beings ever to have lived, an atheist, somebody who simply created fights everywhere he went, never had a kind word for anybody, but we use his name all the time, don't we? He is described as the deviser of the Queensbury rules that governed English boxing matches, although in truth the rules were merely named in his honor after he donated 3 prize cups to a boxing tournament in 1867. That was before he had Oscar Wilde committed to prison for some of the things he had done to his son. So here are the Marquis of Queensbury rules, and many of them apply even today. So here we are, 150 years later? I guess it's the 151st birthday of the Marquis of Queensbury rules. It describes rule number 1, how big the ring should be. Rule number 2, there's not going to be any wrestling or hugging. That still goes on. The rounds are to be 3 minutes duration. I think they're still 3 minutes duration. Rule number 4, if a man falls through weakness or otherwise, he's got 10 seconds to get up. If not, bout is over. If so, the fight goes on. Rule number 5, a man hanging on the ropes in a hopeless state is going to be declared to be down. Give him the 10 count. Number 6, no seconds or any other person is allowed in the ring while the fighters are fighting, except for the referee. Number 7, should the contest be stopped by any unavoidable interference, the referee shall name the time and place to finish the contest immediately so that the match may be won or lost. In other words, there's going to be a conclusion. Rule number 8, boxing gloves. Must have boxing gloves. Number 9, should a glove burst or come off, it must be replaced to the referee's satisfaction. So the referee will inspect the new gloves that go on. Number 10, a man on one knee is considered down, and if struck is entitled to the stakes. Compare that with Roman pugilism, where if a man went down, the fighter got on top of him and the bout continued. Rule number 11, no chutes or boots with springs allowed. I don't understand that one, but I guess it was important enough to put it in. And number 12, otherwise the London prize ring rules apply. So fiduciary duty. We started off with Marlon Brando, and the idea is that the manager, his brother was his manager, has a fiduciary duty, and this is well respected. Managers have fiduciary relationships with the boxers they manage and typically are paid a percentage of the boxer's purse, but the manager is there to protect and to advance the interests of his fighter. In the fight lower right in the circle, you can see the towel being thrown in. I don't know that that's in the Marquis of Queensbury's rules, but it applies. So the corner man, the manager or his second, is there to protect his fighter. If he sees things have gone out of hand for the fighter, he is allowed to stop the bout, and him throwing in the towel will be conclusive. So, the promoter, though, on the other hand, has no fiduciary duty. The role of a boxing promoter is distinct from that of a manager. A promoter who seeks to maximize profits from the match may have interests adverse to the boxer, and for this reason, promoters do not share the fiduciary duties of a boxer's manager. Don, I think that's Don King on the left there. Okay, there's Don King on the left, which brings us to a very interesting case. The case was labeled Don King Productions versus Buster Douglas, and it had to do with a long count. It really started with a long count in Japan. What happened was this. Don King had two boxers whom he was promoting. One was Mike Tyson, the other was Buster Douglas. They arranged a match in Japan. So here's Don King with both of his fighters in the ring. At one point, Mike Tyson knocked down Buster Douglas. It took a while for Tyson to go to his corner. The referee came over and counted. There was some question about whether it was a long count or not, because at number 10, the fight is either on or it's off. In this case, the referee may have taken a little bit more time. The fight continued, and in the end, Buster Douglas won the fight from Mike Tyson. During the course of the match, Don King went up and started yelling at the referee that it had been a long count and that Mike Tyson should have won the match. And afterwards, this discussion continued. Don King took this position, and he took the position of one of his promoted fighters, Mike Tyson, over another of his promoted boxers, Buster Douglas. In the event, it was Douglas who remained the champion, I believe champion of the world, as a result of the long count. But it shows how a promoter can be on both sides of a fighter that he is promoting. All right, so I actually had this clip in here as well. You was my brother, Charlie. You should have looked out for me a little bit. You should have taken care of me. Why don't we run that? This goes on a little longer than the introduction. I want to mention this, as I have up here, as we get to the good part. The Ali Act, Muhammad Ali Act, addresses the potential for conflict between a boxing manager and his promoter. Under the Ali Act, it is unlawful for a manager to have a direct or indirect financial interest in the promotion of a boxer, or to be employed by or receive compensation or other benefits from a promoter, except for amounts received as compensation under the manager's contract with the boxer.
He brought you along too fast.
It wasn't him, Charlie. It was you. You remember that night in the garden? You came down my dressing room and said, "Kid, this ain't your night. We're going for the price on Wilson." You remember that? This ain't your night. My night. I could have taken Wilson apart. So what happens? He gets the title shot outdoors in a ballpark, and what do I get? A one-way ticket to Palookaville. You was my brother, Charlie. You should have looked out for me a little bit. You should have taken care of me just a little bit so I wouldn't have to take them dives for the short-end money.
Well, I had some bets down for you. You saw some money.
You don't understand. I could have had class. I could have been a contender. I could have been somebody. Instead of a bum, which is what I am. Let's face it. It was you, Charlie.
Okay. I tell him I couldn't find you. Said nobody won't believe him.
What's going on in this scene is the beneficiary confronting the fiduciary. That is the boxer confronting his manager. Why did you do this to me? Now, brother to brother, I'm not quite sure about a fiduciary duty of brother to brother. We all know parent to child, but brother to brother, he was his brother, and for the most part, we would like to say that brothers look out for brothers. Unfortunately, having been in litigation for these past 35 years, I know that's not always the case, and especially we see it in the surrogates court. There are others who have fiduciary duties to the boxer. Doctors may be required to account for their acts toward a principal. That goes on regularly. We say principal or beneficiary. In the case of Klassen v. Izquierdo, New York County Supreme Court, so it's down there in the First Department, boxer Willie Klassen had died following a boxing match at Madison Square Garden. His widow sued the ringside physicians and facility. The physicians' motion for summary judgment was denied. They were forced to go to trial to account for what they had done with the boxer who was under their care, to whom they owed a fiduciary duty. In the end, the case was settled, and we go on. So it's after the fight, Don? Did everybody hear that? If you didn't hear that, raise your hand. Don, I'm going to summarize it in order to get it onto the record. So what we just heard from Don is that the fighter collapsed in the dressing room after the fight. He was left there for about an hour. The ambulance that was supposed to be at the Madison Square Garden wasn't there. It had left, and so it had to come back. And by the time all was said and done, regrettably, the fighter had passed away. So the doctors had a duty to tend to the boxer, failed to carry it out with the standard care that you would expect from a physician who has such a duty, and as a result, the physicians were held to account in a court. The class in court emphasized that a physician's duty is the same as it is in any other situation, to practice in accordance with good and accepted standards of medical care. Now, what happens for the attorneys in the room? What happens when your partner has made out the trust instrument or has made out the estate that results in the accounting coming around? In the case of INRI Botkin, I had a partner who had drawn up a will with trust provisions in it. It was challenged by an objector. Actually, the challenge was that the will had been executed while he was under the influence of morphine. So we got into a big argument over when does morphine lay off, when is it strongest. And the law of the state of New York is that a testator or a person making an instrument need only have a lucid moment. And that's what they look for. Was there a lucid moment? And it proved impossible for the other side to prove. But in the meantime, they moved to disqualify me because my partner had been the one who drew up the will, and because he would need to be a witness at the trial. It's important to note, as the Fourth Department held, that the question is not whether my partner needs to be a witness, but will my partner testify in any way contrary to the fiduciary's position? Will he give any controverting testimony at the trial? In that case, my partner was steadfast in his statement that this was a lucid moment, lucid moment, lucid moment. We went over that. He kept repeating it, lucid moment. That was the truth. And because he would not testify contrary to our interests, we were allowed to stay in the case. We have allocation of expenses in fiduciary proceedings because 2110 of the Surrogate Court Procedure Act grants the trial court discretion to allocate responsibility for payment of a fiduciary's attorney's fees for which the estate is obligated to pay. Now, it's a rule of thumb that an attorney can be paid by an estate, by a trust, if he has done anything to benefit the estate. So a fiduciary, for example, who presents his accounts has the right to counsel because he's done the work to benefit the estate, and by proving his account, he provides a benefit to the estate. If the fiduciary loses the case, well, that's another matter. He hasn't benefited the estate, and whether he will be paid out of the fund is another question to be visited by the court. We all, as attorneys, know that we're hired by the fiduciary, but we expect the trust or the estate to pay us. If the trust or estate does not pay us, here's a question: is the fiduciary going to pay us out of his own pocket? That's, again, a question for another day. In the Hyde case, back in 2010, the Court of Appeals reversed its position and decided that in allocating fees in an estate, the court could take into consideration a variety of factors and, for example, could award the fiduciary's attorney's fees against the unsuccessful objectant. It goes along the lines of, if you go to kill the king, you better kill the king. If an objectant goes out and challenges the fiduciary and doesn't succeed, then the estate or the trust will not pay the objectant's attorneys, only if there's a benefit to the estate. So here, in the event that the surrogate ultimately determines that costs associated with the litigation are properly charged to the trusts, and if there's not enough left to cover, the funds may be recouped from the beneficiaries. An important point, again, this was in front of Judge Cass in the White matter. You'll recall I told you that my client had sat down with his sister. She had agreed to him, he said, to an extent, and as a result, he had given her half of the trust funds and taken half for himself. At that point, there was nothing left in the trust, so that when the objections were later filed, he had nothing with which to pay his attorney's fees, and what was ruled by the appellate division in Ray White was that if the award comes down, then the estate can go back and get the money back that it had already dispersed to the beneficiaries. I'll briefly note that The EPTL has been amended and now provides for privacy considerations concerning digital assets. These are especially challenging situations, being intangible property. There was limited precedent for the accounting of digital assets, but the legislature ruled that the same legal duties imposed on a fiduciary with regard to tangible property shall also apply to digital assets, including the duties of care, loyalty, and confidentiality. So, in the end, coming back to boxing, we have a lot of very successful boxers out there, but a lot of boxers earn a lot of money over their career. Jack Dempsey, back in the 20s and 30s, one of the greatest boxers of all times, he ended up earning over $4 million during his lifetime. Was it Jack Dempsey was the greeter at the restaurant for many years? Dempsey's restaurant in New York. So he always sat in the window of the restaurant so everybody saw him. I guess that probably brought a few people in. He lasted a long time, but ultimately left an estate valued between $100,000 and $250,000. Bear in mind, $4 million back in the 20s and 30s is probably worth 10 times that much now. Sugar Ray Robinson. Robinson earned approximately $4 million during his boxing career, but spent most of the money by the mid-1960s. When asked about the money, Robinson said he had no regrets. If I had the chance to do it over again, I'd do it the same way. I didn't gamble away my money. I used it to let people live. I took my family and my friends on trips with me. I loaned it to strangers to pay their bills, and sometimes I didn't get it back. So he earned quite a bit, didn't leave much of an estate, but he did it the way he wanted to do it. Joe Frazier. You know, when I was growing up in the 60s and watched Muhammad Ali with the legal problems and having his title taken away from him, and the Supreme Court ultimately saying that his conscientious objector status was fine by them, he was given back the right to fight. And I was in Shays Buffalo, I don't remember exactly when it was, 69, 70, for the first Ali-Frazier fight. What a fight it was. I can still remember. They had trouble. It was 1969 or so we didn't have television projection screens. Somehow, though, they managed to do a live projection on the huge screen at Shays Buffalo. The place was packed. What a fight. Was it the 14th round? Frazier finally knocked Ali down. But Ali came back. He finished the fight on his feet. Was it a 2-1 decision? It was a split decision. Muhammad Ali coming back. There's the tail of the tape. Frazier didn't meet Ali before that fight, but somebody labeled Muhammad Ali as Cassius Clay for purposes of the tail of the tape. You see these things. In this case, Joe Frazier was what? 3.5 inches shorter than Ali. On the reach, he was giving up 7 inches, which means that as Ali was floating like a butterfly, he was also stinging as a bee from outside the range of Joe Frazier. But Joe Frazier got inside, as a good boxer of his sort should, very powerful puncher, and he won the day. In his later years, can you go back a slide? In his later years, Frazier lived in a small apartment above his Philadelphia boxing gym. He closed the gym shortly before his death in 2011 due to debt and back taxes. He just couldn't afford to keep it going. Okay, finally, famous estates Muhammad Ali. Now, Ali had good advisors, and he had an estimated $50 to $80 million fortune at the time he passed away. We've gone looking for any estate proceedings involving Ali, and my colleague, Pauline Muto, thank you, Pauline, for helping me put this together, contacted the attorney handling the estate. Apparently, there haven't been any lawsuits yet. How many kids did he leave? 9? 9 kids, who so far are getting along fine. That's a lot of money for them to split up. Their licensing going forward, the Ali name has a certain ring to it. All of us remember from the 60s what he did. And of course, his career is one of those storied legends that everybody remembers. There have been rumblings of a dispute over the estate since his death, but nothing that has come to pass. So that brings us to pretty much to a close, I can tell you this. Not all boxers end up dazed and out of the way. Muhammad Ali had Parkinson's, but he steadfastly maintained it wasn't due to his boxing. It was something else altogether. Some boxers don't come out so well. Jake LaMotta, though, took to the stage afterwards, and we thought we would end up this presentation by showing you a boxer who ended up reciting Shakespeare. This is De Niro.
Those cheers, they still ring in my ears, and for years they remain in my thoughts. Because one night, I took off my robe, and what I do? I forgot to wear shorts. I recall every fall, every hook, every jab. The worst way a guy can get rid of his flab. As you know, my life wasn't drab. Though I'd rather hear you cheer when I delve into Shakespeare. A horse, my kingdom for a horse. I haven't had a winner in 6 months. And though I'm no Olivier, I would much rather. And though I'm no Olivier, if before Sugar Ray, he would say that the thing ain't the ring, it's the play. So give me a stage where this bull here can rage, and though I can fight, I'd much rather recite. That's entertainment. That's entertainment.
Well, thank you very much for hearing me out. I've tried to get some boxing involved with the fiduciary status over the years. Appreciate your kind attention, and everybody have a good day in this beautiful April weather.